Well, today's judgment is providing clarity on the rights of citizens to stand for public office. Let's unpack then what today's judgment means. We are joined by Pansy Tlakula, Advocate Tlakula that is. She's the chairperson of the Information Regulator of South Africa. In her other life, she was the former chair of the IEC. Joining us later will be Professor William Gumede. Advocate Tlakula, good evening, and thank you so much for your time. You know, when one looks back, it's interesting because you were part of the people that sat when this country looked into potential electoral reforms. It was over 15 years ago. When you look back and you realize the implications of today's judgment, what does it really mean?
Oh, today's judgment is quite complicated in terms of its implementation, really. I am aware that there is a minority and a majority judgment, as you are aware. And the majority judgment really concentrated on the link between the rights in Section 19 and the rights in Section 18, in particular 19.3, which talks about the right to stand for office and, if elected, to take up office. You see, my challenge, I think, is that, and I've always said this, that I thought that the constitutional arrangement is such that the whole constitution should be interpreted contextually. And that the system that has been agreed upon, if you look at the Constitution as a whole, it's a proportional representation system, which is unpacked in the Electoral Act. And if you take that view, I don't see how the Electoral Act can be unconstitutional. But having said that, the majority judgment is there. We can unpack it, we can interpret it, but it has to be implemented. And I think the implementation is where, for me, the challenge is going to be, because I'm not sure how in a national and provincial government you are going to have a mixed system where some of the candidates will be independent candidates and others will come from lists. There are serious implications for that. The first one, I think it was referred to in the minority judgment, is whether that system will result in proportionality and whether that system will result in every vote counting. I can give you an example. Assuming the Constitution says that the Constitution will consist of 400 members, isn't it? For now, these 400 members, 200 of them come from national lists, 200 come from regional lists. That's what that, and the system, where after the voting, when you count, the system must result in proportionality. Let's take an example that 100 members of the National Assembly, 200 will be independent candidates. And when you're an independent candidate, you are elected through first past the post, which means that whatever number of votes that you get, you are in, you know. So if 200 are elected as independent candidates, they could be elected, all of them, with a mere 30% vote. And then the 100 can come from parties, the remaining 200, and assuming that those 200 are elected with 80% of the vote. But they won't get 80%. They will get only 50% of the seats. And that is where the proportionality is distorted. And that it means that every vote will not count. So there are those issues that we need to put on the table. We also need to put on the table, if you are talking about this, it means that you have to demarcate the country into constituencies, and the independents will contest in those constituencies. With a spatial, racial spatial arrangement that we have to look at the implication of what that is going to mean. It means constituencies are going to be made up in the suburbs of white people, let's call it that. So from the white suburbs, former white suburbs, will have white members of parliament representing their constituencies. So, but as I said to you, this is a judgment that we have to implement. I don't know how Parliament is going to do this. Are they going to change the electoral law, or are they going to change the constitution? Maybe changing the constitution is more like it.